help me welcome to the Doralicious Show, straight from Nevada. Και παιδιά, πραγματικά σας το λέω, he's born and raised in Las Vegas. He's a rare breed. Elias George, U.S. attorney from EPG Law in Nevada, εδώ στην παρέα μας. Τι μου κάνεις? Welcome.
Hey, thank you very, very much for having me. I'm really excited to be here today. This is my first time appearing on a radio talk show being hosted out of Canada.
Well, welcome. I'm glad to be your first experience, and I'm pretty sure it's not going to be your only one.
I hope so, but they always say you remember your first, so I'm definitely going to remember this one.
I'm very, very memorable. Τι να κάνουμε, λοιπόν. Straight to the deep waters. What was your initial reaction on Monday night when Politico came out with a leaked draft version of Justice Alito decision from the Supreme Court?
So, do you want to know my opinion on how I felt about a draft opinion being leaked, or do you want to know my opinion and my reaction to reading the contents of the leaked opinion?
Let's start with the first one.
So the first one, to say that I was absolutely shocked, jaw-dropping, is really an understatement. Now, for some of your viewers to really kind of appreciate and understand the American legal system, at least as it relates to the U.S. Supreme Court, the U.S. Supreme Court is a 233-year-old entity. It has historically been very, very secretive. Nobody understands nor appreciates its internal machinations, how judges come about their decisions, how they determine who's a majority, who's not a majority, and even the process generally by which they deliberate amongst themselves. And that deliberative process is inherently very secretive. And the reason why it's secretive is because the point of the U.S. Supreme Court branch of government is to not step into the toes of politicking. The U.S. Supreme Court wants itself to be viewed as a standalone, very secure, and very respected institution. And never in the history of the U.S. Supreme Court has a draft full opinion ever been leaked, ever. Historically, we have had leaks of perhaps deliberations that have gone on. We have actually had leaks either days before or hours before of a final and signed opinion, but never have we ever seen a first initial draft of a leaked opinion. And that's truly unprecedented. And if I can, though, and I'd like to add just one more thing, because this is really important for your listeners. Because there are 9 U.S. Supreme Court justices, and they do not engage every day at the cafeteria discussing, remunerating over their ideas, they discuss amongst themselves through their brief writing. So this brief that was produced by Justice Alito is in fact strongly worded and is an effort and an attempt to lobby his own colleagues in the U.S. within the U.S. Supreme Court to perhaps capture a larger share of the majority. So we not only got a glimpse into the opinion of Justice Alito, but we actually got now a glimpse for the first time in over 200 years, the internal politicking that is happening amongst these 9 judges.
So you read the decision, and
it was long.
And Justice Alito writes that Roe was egregiously wrong. Was it for almost 50 years?
So I think it depends on what side of the political spectrum you're on. So if you are in America, if you are a proud conservative, if you are one who has long been pro rights or
pro-choice.
Pro-choice, excuse me. It's a little late here in Las Vegas. If you have longly been, depending on what side of the political spectrum you're on, I don't think conservatives would find it to be egregiously wrong. In fact, I think conservatives in America, candidly, are finding it to be spectacularly amazing. They're on the streets and they are joyful. On the other side of the political spectrum, you have those who are pro-choice. You have those liberals who believe that the opinion that Justice Alito is writing is egregiously wrong. So the reality is that, and this goes back to my initial point to you, Dora, which is we are now getting a glimpse into the internal politicking that is happening amongst these 9 judges. Will that key language, egregiously wrong, stay in this draft opinion? Nobody knows. Maybe even the justices don't know. But I also think it's important to understand that the opinion that's, about 90 pages long, is really just an initial draft. And it very well could change. And we also don't know what judges have signed on to that. We think we know based on reporting of Politico. But again, that very well may change. And what may happen as a result of the internal politicking is maybe the US Supreme Court doesn't fully overturn Roe v. Wade, but perhaps just cuts it down further, if you would.
No, and I think you touched on the point that it's still a draft. Obviously, given the affiliations of the judge and who appoint them versus the Republican versus the Democrat, we kind of have an inclination of how they're sitting. Vamos a dilemmatake, and I want to come back and discuss about the possibility of the overturn and what does that actually mean. So stay tuned. And this is the Doralicious Show with Elias George, U.S. Attorney. And we're back here on the Doralicious Show with Elias George to talk about Roe v. Wade. Roe v. Wade was a seminal decision from the United States that allowed abortion rights for women. Now, based on the draft, things might be changing. So, Iliamu, how do you think the United States will look like if Roe v. Wade is overturned?
Wow. I think to answer that question, there's two parts. In the first part, I'd like to borrow a phrase from Jeffrey Rosen, who's a well-known law school professor here in America. And he stated that if the Supreme Court overturns Roe v. Wade, it will set off tectonic shifts in the American political landscape not seen since the Civil Rights Movement or perhaps even the Civil War. With that in mind, I think we need to then focus on the second part, which is the impact of Roe v. Wade is not simply right to privacy, is not simply women's right to their body, is not simply whether you're pro-choice or pro-life, but it really strikes at the very heart of how our system has been built, forming from a decision as to right of privacy. Let me explain what I mean by that. The term right of privacy and this idea of privacy is not mentioned anywhere in our Constitution. But there have been a great deal of decisions, even predating Roe v. Wade, most famously with a case called Griswold versus Connecticut from the 60s, that found that there was a right of privacy in the shadow of the Constitution. They use the word penumbra, which is a bizarre word, but it essentially means the shadow. And essentially what they were arguing is that this idea of privacy is implied in the Constitution. That argument that the Constitution implies an affirmative right to privacy was the legal basis that was used to secure a handful of rights that we are all enjoying today. Number one, most famously, most recently, the Hodges decisions where they legalized gay marriage. They essentially relied on a right to privacy theory. Roe v. Wade, right to privacy theory. Lawrence versus Texas, 2005. That was a decision that allowed consensual sex among same-sex couples within their own home. And we also even have the Griswold versus Connecticut case, which allowed for a constitutional right to contraception. And there's a whole host of additional rights that all of us in America enjoy that flow from this theory that the Constitution protects us vis-a-vis our right to privacy. If we look at the significant draft opinion of Justice Alito, he undermines that completely. He does say in his defense that the argument for or against abortion is very different than all these other rights that we enjoy. However, many argue that he's essentially creating a playbook that can be used to override many of the constitutional rights that we as Americans enjoy. And much like how the leaking of this draft opinion is unprecedented, the U.S. Supreme Court overturning longstanding precedent where it is not expanding individual liberties, but rather restricting individual liberties is unprecedented. And based on my research, has never been done before.
We're going back. When I was in law school, the one thing that we always talked in Canada is about the living idea of a constitution, that it grows, it evolves, it adapts to changes. We can't be making the same decisions the moment society has changed. So now we're going back. And let's say in a very Margaret Atwood novel that we go back, what states will be mostly affected?
So the states that are most likely to be affected, there's about 13 states that have what are known as so-called trigger bans, which means that once Roe v. Wade is in fact overturned, and assuming it is, of course, uh, these are states that are much like Missouri or South Dakota or Tennessee or even Utah. And there's about 13 of them. There's a handful of other states, and it essentially amounts to about 25, maybe 26 out of the 50, where abortion would become illegal, or the woman's right and ability to have an abortion ranges anywhere from 4 to 8 to maybe 13 weeks. There are a handful of other states, about 22 of them, where there's a state right to an abortion that's either established in each state's constitution or state statute. We in Nevada have a state statute that essentially mirrors, it's a little more restrictive than Roe v. Wade, but it does provide for a statutory right to an abortion, which actually hits on a really interesting part, because if the draft opinion stays,
Mm-hmm.
it's crucial to understand this. The opinion isn't stating that abortion is unconstitutional under the American Constitution. It is only stating that abortion is not an affirmatively protected right under the Constitution, meaning the justices are leaving it to each of the 50 states and its surrounding territories. So now about half, a little more than half of those states, abortion will be illegal or illegal within a respectable range, and the remaining half, it will be a right, which now is going to breed a completely new industry, a new legal ground. So you are going to have mothers, families traveling from a state where it is illegal, perhaps Connecticut or Tennessee, to a state where it is legal, like Connecticut, for example. Mm-hmm. And now there are discussions about the possibility of some of those conservative states that are anti or that are against abortion and pro-life to pass statutes that would make it criminal
to do that
for their citizens to travel across state boundaries in order to seek an abortion in a state nearby where it's legal. My opinion is I don't believe that that would pass constitutional muster. Yeah. There's a case from 1963 to 65, I believe, called Loving versus Virginia, and this was an interracial couple. They had left Virginia, where interracial couples were not allowed to marry. They then traveled somewhere, I don't remember where, to become married, which they were able to. And then they went back to their hometown, and that hometown criminally prosecuted them as violating their state statute against interracial marriages. The U.S. Supreme Court in that case articulated that that statute in that state was unconstitutional, largely because it had a desperate effect and a desperate impact on, or an unfair impact on that couple. It didn't really touch on the issue of extra jurisdictional or people, kind of traveling over one boundary to another. But there is some precedent there that would kind of argue against that. So I think, and the last thing is, we, especially in light of the pandemic, we've all have used in some form or another, telemedicine, telehealth. So what if we have a young girl in a conservative state where abortion is completely illegal and outlawed, and she pops on her iPhone, conducts a medical visit with the doctor based out of California, gets a prescription for the day after pill or some pill that would induce an abortion, and that pill is then mailed to her. Is that a violation of California law, Connecticut law, Texas law? Texas has recently passed a statute that would suggest that that's an illegal action, but nobody really knows whether the transmission of medicine across state boundaries is in violation of state law. We just don't know.
We don't know. And there's a lot of issues, like there would be ultra vires within the states, or whether they would fall within federal jurisdiction or the state jurisdiction. But before I let you go, what was your favorite, and I'm using the word favorite jokingly, part of the decision of Justice Alito, and why?
My most favorite?
Yeah.
I don't know if it's my most favorite because I'm not an opinion. I'm not in favor of the opinion, but I would say that what is the most shocking part of the opinion is that Justice Alito cites numerous times to Sir Matthew Hale, who is an English jurist, for support that there is historical precedents against abortion. And based on some, preliminary investigations, not done by me, of course, but by some experienced newscasters and journalists, that Sir Matthew Hale was a misogynist. He, had prosecuted, I think, at least 2 women for engaging in witchcraftery. I believe he was also a big supporter of marital rape. He also was a fan of imposing the death penalty on children even as young as 14. So, I wouldn't suggest seeking legal or at least medical advice from Sir William Hale, but at any rate, it appears Justice Alito thought it valuable. So that to me was equally as shocking as the leaking of the opinion itself.
Elian, thank you so much for your opinion. Thank you for giving us your insight in terms of how the Constitution works and how this potential overturn of the decision could affect Americans. Thank you for your time.
Thank you. Thank you.